Hello friends, in the series on the income tax cases, today we will discuss a issue that if the assessee is involved in the business of providing services which are related to the prospecting, extraction or production of mineral oil, whether this will be covered under section 9 subsection 1 clause 7, which talks about the managerial, technical and consultancy services. In the present case, the title of which is Deputy Commissioner of Income Tax International Taxation versus Western Geco International Limited, and which has been reported in 108 ITR Tribunal Short Notes 23, and the matter has been decided by Honorable Delhi ITAT C bench, and the date of the judgment is 31st May 2023. In this case, the business of the assessee was connected with providing services in connection with prospecting, extraction and production of mineral oil. The assessing officer during the assessment proceedings took this income under section 9 subsection 1 clause 7, which talks about managerial, technical and consultancy services. In this case, one more issue was there, that there was reimbursement of service tax which the assessing officer taxed, and it was the submission of the assessee that the assessee has received the amount of service tax reimbursement and it is not a part of the income of the assessee, and on that service tax component section 44BB should not be applicable. When this matter came before the CIT appeal gave relief to the assessee, so the department was before the tribunal. Tribunal, while giving the verdict of the court, the tribunal said that in the present case, section 9 subsection 1 clause 7 has been introduced by the assessing officer into the assessment of the assessee, but if we read section 9 subsection 1 clause 7, there is explanation 2 which specifically excludes the income of prospecting, extraction and production of mineral oil. So in the present case, if the assessee is taxed under section 9 subsection 1 clause 7, that is not justified. The tribunal also upheld the order of the CIT appeal that amount received by the assessee as reimbursement of the service tax cannot be taxed. The tribunal said that the assessee will cover under section 44BB that talks about special provision for computing profits and gains in connection with the business of exploration etc. of mineral oils, and the assessee will not be covered under section 44DA, which talks about special provisions for computing income by way of royalties. In the nutshell, the tribunal deleted the addition made by the assessing officer, in which the assessing officer has taxed the income of the assessee which was from the services relating to the prospecting, extraction and production of mineral oil into the head section 9 subsection 1 clause 7. In this case, one more important issue was there which was discussed, that what is technical services according to section 9 subsection 1 clause 7. If we see section 9 subsection 1 clause 7, there are three words. First is managerial, second is technical and the third is consultancy. The technical word is sandwiched between the two words, that is managerial and consultancy services. So for defining the word technical services, the Mumbai ITAT in the celebrated case of Reliance Communication Limited versus Assistant Commissioner of Income Tax said that when there is a word in between the two words, then that word will take the color from that two words according to the principle of nociture a sauces. As all we know that the managerial services and consultancy services are related with the human element, so drawing the same analogy, technical services which is there in section 9 subsection 1 clause 7 will also be related to the human element, meaning thereby that the technical services which are the result of some machine will not be covered under section 9 subsection 1 clause 7. So in this case, tribunal confirmed the order of the CIT appeal. At the end of this video, once again I am repeating the name of the case. The name of the case is Deputy Commissioner of Income Tax International Taxation versus Western Geco International Limited, and this case matter has been decided by Delhi ITAT, and the date of the judgment is 31st May 2023. Thank you, friends.